Hey guys, good morning. You guys hear me okay? Been having a little bit of a problem with my mic. It would not be the same stream if we did not start with the immortal words of Freddie Mercury. Appreciate that, David. And I'm going to use the wrong mouse. Finally have a second screen. I brought my laptop out here. But now I have two mouses, so I'm going to be using the wrong mouse all day. um, so I think that Law and Crime Network is streaming the hearing this morning. Um, at least I certainly hope that they are. It looks like they are. If I can get StreamYard to cooperate. So it looks like they're all ready to go. It says it's going to start at 9:30. I don't know why they're starting at 9:30. I thought they were going to start at 9, which is why I had it set for 9. But yeah, she has one son from a previous marriage, and he has, I know, at least one daughter. And the the police did not want to arrest her in front of her son, which I thought was very nice, because they didn't have to do that. They could have gone right over there and arrested her in front of her 10-year-old son, and they chose not to. And they asked her to come down to the sheriff's office because they wanted to talk to her about the autopsy. Well, they told her the day before that the next day they would want to talk to her about the autopsy and ask her some more questions. And then I I don't want to say made up, because I don't know. Maybe she remembered it differently. But she said that Chelsea Copsall, the detective who was pregnant at the time, called her and said that she wasn't feeling well because she was pregnant. And she said something like, "You remember how it was when you were pregnant?" That she just didn't feel like driving over to the apartment to give her phone back. Could she please come to the sheriff's office? Which she did. And then Sarah said that Scott Lowen, the other detective, came out and said, "We need to go upstairs. Your phone is upstairs." But they did not question, whenever they had that hearing, they didn't question Scott. Only Chelsea came to testify. And she said that that was not the way she remembered it. She never said anything about coming to pick up the phone. She said that she told her that they would have more questions the next day. But she did call her to come to the station. And then when the interrogation video starts, the first thing Chelsea says is, "Appreciate you coming down." And Sarah had a list of questions for them too, which, I mean, that's normal. I would too. If my loved one had died, I'd have questions for the cop, I would think. So, yeah, and Sarah said she was at the crime scene for like, what was it, 10 plus hours? Which from 1 p.m., 10 hours would be, I'm terrible with math. 12 hours would be 1 a.m. So, what is that? 11 p.m.? Hey, Dracomie! Yeah, so 11 p.m.? Did I do my math right? Like, yeah. And so, but she said what? She said she called Chelsea around 9 that night from her ex husband's house. So that doesn't fit. Yeah, you're right, David. That doesn't fit. Um, Either she's misremembering or she's making up stuff. I'm not going to accuse her of making up stuff. I'm just going to say either misremembering. I mean, I imagine it was a traumatic experience because, like I said, I don't think she meant him what happened. I don't want to keep using the bad word, the word that YouTube doesn't like. Except now I'm sure they've caught on to unalive meaning the same thing. Because I want to get monetized. I'm almost there, y'all. Well, I shouldn't say almost. I'm halfway there. So, yeah, they were being nice and didn't want to arrest her in front of her son. And now she's like throwing them under the bus. Oh, they tricked me to come down there and. No, they didn't. They did not. And then Owens is saying, oh, well, they said it was just protocol. And they said, oh, we just have to do this. Like, belittling, trying to make it like it was something that they just had to do, like minimizing the Miranda rights, like it wasn't an important thing, to try to make it seem like her being arrested was not a possibility. You guys, anytime you're read your Miranda rights, you could possibly be arrested. Don't ever think that it's a trivial thing. If they say, oh, we just have to do this, or it's just protocol, or just standard operating, or whatever words they use, it doesn't matter. If you read your Miranda rights, shut up. Don't say anything else without a lawyer. Just don't. My dad was a cop. I remember, I didn't know. My dad was highway patrol. And in Florida, the highway patrol is just that. They're not like state police, they're just highway patrol. So I thought my dad just wrote speeding tickets. And, we didn't have YouTube back in the day. I'm old, y'all. So I never watched like drunk driving, drunks getting pulled over, and many times I have seen my dad get up from the dinner table and go, well, gotta go catch me a drunk. But I never seen it, so like I knew my dad pulled over drunk drivers, and it never dawned on me. I just thought my dad gave tickets. Like it never dawned on me that drunk drivers then have to be taken somewhere. Like you don't let them get back in the car and drive. I was a kid. What did I know? And so one day I'm sitting at now I'm an adult now. I'm a nurse. I'm not married yet. I'm like probably in my early 30s probably. I'm sitting in my house and I'm watching Law and Order. And all of a sudden it dawns on me and I pick up the phone and I call my dad and I'm like, Dad, have you ever had to read anybody their Miranda rights? And he goes, well, of course. Like, And it just dawned on me, oh my God, my dad's a real cop. He just. So now when I watch these videos, it frightens me. I'm like, I am so glad I didn't know what my dad actually did for a living. Because I would have been worried about him all the time. I would have been scared to death. I've been like, oh my God, what's he doing now? Who's he pulling over now? What crazy person is fighting him right now, you know? But yeah, if you read your Miranda rights, shut up. Don't say another word. Wrong mouse again, Debbie. $2 minutes and 40 seconds. Oh, I hope they live stream it. I mean, I know they have the placeholder there, but just because there's a placeholder doesn't mean that it's going to be. Yeah. And on those videos that we watch on YouTube all the time, the dumb ones will say, "Well, you didn't read me my rights. You didn't read me my rights." Hey, twin. But you don't have to have your rights read unless you're in custody and being questioned. So if they're not asking you any questions, you don't have to have your rights read. If they're just, you know, if they're stopping you for a speeding ticket or whatever, and then you refuse to give them your identification, and then you won't get out of the car, and then you resist and fight them, and they handcuff you and stick you in the back of the car, and then don't ask you anything, they don't have to read you your rights. So I always laugh when they're like, you didn't read me your right. You didn't read me my rights. You didn't read me my rights. They don't have to. Unless they're asking you questions. They don't have to. And I always say that they have the right to remain silent, just not the ability. And that's like with Sarah. She did not have the ability to remain silent. Right. If they don't read you your rights, they can't use it in court. Hey, you. Yeah, I learned that when we watched the Rust trial because I thought prop guns were prop guns. I didn't know they were actually real guns. Waiting for law and crime. I should probably put some earbuds in. I can't wait till I get a real desk, y'all. I'm so cramped up right here. I got a fan, I got drinks, I got one mouse pad, two mouses, I got a notebook, I got a computer, laptop, I got all just scrunched in right here in front of me. My kids need to come get their junk out of my spare room. Oh, I think they're dead. Why are you dead? They were charged. Yeah, but I need everything up here. If I had something that I could put this fan on, so it'd be over here. We have got the weirdest ventilation, I guess, or air ducts, or I don't know. Some rooms in this house are perfect as far as getting enough AC, and then other rooms, like you can feel the temperature change walking from one room to the next. Yes, welcome to our pre-show, folks. Oh, there was a video on Biggins' channel the other night where uh, there was a drunk girl that kept calling the cop daddy. And the cop was like, "Quit calling me daddy. I'm not your daddy." So yeah, this is the one of the warm rooms in the house, and I don't know why. Well, maybe we've got like maybe it's because it's so open. Spike, y'all want an old dog that doesn't like to go outside to poop? I'm gonna kill him. I'm gonna kill him. We've got like an archway between this is the dining room and then the living room is in there. I wonder if that's why, that's probably why this area is always warmer. If it was like two individually closed off rooms, it would probably be cooler. Because if you go in the kitchen, well, the kitchen's not partitioned off from the dining room, but it's cooler in the kitchen and it's cooler in the bedrooms. This whole area of the house is warmer. I don't know. That's true. Computers do make a room warmer. My dad built this house with one contractor, and my dad did not know what he was doing. We catch stuff all the time, like places where door jambs aren't lined up right. And because, I mean, I can't complain because I inherited this house and there's no mortgage on it. So, but we catch stuff all the time, and we're like, why did my dad do that? So, in fact, there's where the air conditioner is, it used to drip water, and they just had a bucket underneath it. And we had to like watch the bucket and change the bucket out until my husband fixed up a hose system so the water goes outside of the house now, so we don't have to empty a bucket continually. Like, why did they like I don't understand why my dad did the things that he did. Come on, Law and Crime. I guess they haven't started yet. I hope they stream this. Oh, wow. Well, that's not fun. We have one spot where our roof leaks. And um Travis has been on the roof, I don't know how many times. And I always get roped in to help because he's afraid of heights. So I have to go hold the ladder while he takes forever to climb it because he's afraid of heights. And it takes him forever to get up there and forever to get down. When he gets to the top step, he stands there for minutes before he finally gets on the roof. And then I worry because when you're afraid and you're more careful, sometimes that makes you more klutzy. So I'm always worried that he's going to fall because he's being too cautious. You know what I mean? But anyways, he's been up there. He's tried all kinds of different things, and he says it's not fixed, but I think it is because we didn't have any water. We've got like a bowl. There's a shelf in the laundry room that's high, so we have a bowl there to catch the drip. And the last 2 hurricanes, we didn't get any water in that bowl. So I'm pretty sure it's fixed because we got a lot of rain from both of those hurricanes. So I think he fixed it on the last go round. But one of the other hurricanes, I think it was last year. One of the hurricanes. It actually caved in the ceiling a little bit, and it's our laundry room and our shower back up against each other. So it's part of the laundry room and part of the shower, and it's like that. So the ceiling of our shower and the ceiling of our laundry room are like separating, and I'm afraid the shower's gonna fall in on me one day. At least it's the shower, though. Be easy to clean up. You always got to look at the silver lining, right? Why is it? Come on, y'all. It's 9:38. Does that mean they're not streaming it? My dogs are good. I took them to the vet yesterday to get their nails cut. My one with the urinary tract infection, I think she still has it. Her urine's clear, but every once in a while she'll have like a little drop of blood in it, which is weird because usually if you have a urinary tract infection, your urine just looks like dark and gross, but hers is clear as a bell except for like a little drop of blood every once in a while. And my other one he's his normal stubborn, spoiled rotten self. He just refuses to go outside to poop. My husband, I've lost track of the number of times this carpet has been steam cleaned. Hey, Flash fan. That's what I'm wondering. That is what I'm wondering. Because, like, I'm thinking she could have, like, crystals or something that's causing the blood. Because those crystals are, like, little jagged pieces. So I'm thinking that could be what's causing the blood. Like, it's not really an infection. But that costs a lot of money to figure out. And we don't have that kind of money right now. And she doesn't seem to be in any pain, although that is usually very painful. But if she seems to be in a lot of pain, of course we're going to do something, but she's her normal self. So now when she had the urinary tract infection, she did act like she was in pain. And she would also, I think she felt like she had to pee all the time. She was always wanting to go out to pee, and then she'd squat and she wouldn't pee. So, and then like she'd walk a little while and then she'd pee and then she'd just dribble. And then she'd walk a little while and then she'd squat and then she'd pee. So that's a urinary tract infection. I know that from experience. So Flash fan, I don't know. I thought it was going to start at 9 and then it said 9:30. and it's 9:40 now, so and it still says waiting for law and crime. Recovery Addict has people down there like I don't understand it. He has some kind of a deal worked out with Trial TV Live. And I think he's going to use them when he covers the trial. And where you are, don't scare me like that. For a minute, I was like, what? um, so I was gonna ask him. Actually, I did ask him, but then I saw this. I couldn't find like the little placeholder thing like this for this hearing. And I asked him if I could use the Trial TV Live. And then I said, oh, never mind. Because I found this one. And he's having trouble. I guess they're giving media a hard time down there. I wanted to go. I really, really wanted to go. Yes. Draco and me is from the future. She's a time traveler. Oh, whoops. Oh, I didn't mean to do that. I went out a couple weeks ago, month ago, I guess. And on the way home, my car felt different. I know nothing about cars, and my husband knows just about everything there is to know about cars. And he used to be a race car driver. Well, quit living in the past. I keep telling you that. I do it too, though. And then when we get together, we do it together. And then we get maudlin, and it's not a pretty sight. um, so I don't know, I went out to get lunch or something, and on the way home, my car started feeling sluggish and weird and wasn't sure what was going on. So I finished driving home, and I was telling when he got home from work, I'm like, honey, there's something going on with my car. I don't know. It kind of felt like I had the emergency brake on, but I didn't. I don't know what. I have no idea what's going on. So he said, it's your shocks in the back. Watch. And he went over and he's like pushing the back of my car. And then he looks at my right rear tire and he goes, your tire's flat. And I said, what? I would have known if I had a flat tire. That's not what I felt. The tire had dry rotted, and it it was like cracked where it was like a slow leak. I was lucky that tire did not blow out and cause an accident. So we replaced the back two, but we haven't replaced the front two yet. And Travis said he didn't. I kept saying, I want to go down there for at least just one day. I want to go down there a day when Peter Tragos and Brandy Church rolls there, so I could at least see the trial one day and meet them. And he's like, I don't think your car's going to make it. I was like, what do you mean? You just don't want me going down there. And he goes, no, that's not it. I don't think your car's going to make it. I'm worried about your tires. 2.5 hours away from home in Orlando traffic, I have a blowout, I'm screwed. So I get it. So I'm good. I mean, I'm not good. I'm disappointed, but I guess I'm good. Oh, Robbie, prayers. I also, while we're waiting, I'm starting to think they're not gonna stream it. I do have a sweet husband. I am very blessed. Um, I'm not gonna have the back surgery right away. I am. I was so excited when I found out that I was a candidate for the neurostimulator because I thought, yay, that's going to solve all my problems. I'm going to get my neurostimulator. I'm not going to be in pain anymore. And then I got to talking with the pain management doctor because my neurosurgeon was on board with what I wanted. And they referred me to the pain management doctor. And he was okay. He was like, yeah, we can do that. But I was thinking that it was not. It's Eastern. She's in Florida. So it should be Eastern. So I was thinking that the stimulator, because it's day stay surgery, that it wasn't like a major surgery, but it actually is kind of a big surgery. So I decided to go ahead and start with the shots. So on the 23rd, I have to get a shot in my back. So on that day, and I think that's next Wednesday. So that day we're going to start late. But we are going to do it that day. So if I'm, I'm not here, like right when it starts, hang tight because I will be here. We'll just start late that day. Yeah, my husband, I'm so blessed. I couldn't ask for a better husband. One day, I almost cried. We went. I guess I had a doctor's appointment or something, and my back was hurting me really, really bad, and I had to leave to get to my doctor's appointment at the same time he left for work. And he goes, you need to get gas. Follow me. And because he goes to the store to get breakfast where the gas pumps are. So he goes, just follow me and I'll fill up your car when I get breakfast. So I pulled up and I was going to get out and pump the gas. And he goes, no, stay in the car. I'll pump your gas. And I was like, oh, thank you, honey. And then while he's pumping the gas, he got the squeegee thing out and cleaned all my windows for me. I just about cried. I was like, how did I get this blessed to get this man? What what did I do so right? Like I don't and he's like that all the time. Like I mean all the time. Oh, dang it. Why? Why? See, I was going by Joel's update yesterday because I guess it was at lunch yesterday. He live streamed from the courthouse. Well, Nancy, I was 38 when we got married. So I went through a bunch of jerks before I found the right one. Yeah, it's nice when you find the right one. And another thing too, um, I I don't want to say that I'm insecure, but I know that I don't have to be with him because his first wife cheated on him. So I don't ever have to worry about him doing that to me because he knows what that feels like. You know what I mean? So that never has to be an issue with us. Not, I mean, I don't think he would do that just because of the man that he is. But if that ever were to cross my mind, I know he wouldn't do that because it's happened to him. So, he does love me. And this is how I knew that he was the one. He lived like um 2 2 hours south of me when we met because I worked with his ex-sister-in-law. And his ex-wife and kids lived up here, and he had come up here for Thanksgiving. And I started going down there to visit him. And um one day I was there and he was at work, and I had taken my cell phone with me but forgot the charger, and my phone died. And I have fibromyalgia, and we had talked about that. At the time, I didn't have like all the arthritis and the degenerative disc disease and all the other garbage that I have now. Um, but I had the fibromyalgia, and I had told him what it was and explained to him and how that I hurt and I got really tired and that kind of stuff. And so he was trying to call me while he was at work, and my phone was dead and he couldn't get a hold of me. And it scared him so bad, he left work to come home and check on me. And that right there was when I knew this is a keeper. Because he didn't have to do that. Not at all. He could have just kept working and then, came home after work to check on me, but no. So, hey, James. Whoa, you had 20 shots at the same time? Do the Botox injections work? I've never had those, but I've heard about that for migraines. Oh, I know how to pump gas. I absolutely know how to pump gas. But I've forgotten to do some things around the house. He washes the clothes. He loads the dishwasher. He does all kinds of stuff. And I never asked him to. He just took it over. This child better not. Well, I didn't want to get the shots, and I told the pain management doctor why. Um, the last time I got a shot, I know some of you guys know I had my shoulder replaced last year. The last shot that they put in my shoulder hurt like hell. It was horrible. Not only was it horrible, it didn't help at all. And the other shot that I had over a year before didn't hurt anywhere near as bad. I remember that was the first shot I'd ever had in my shoulder, and I remember going, "Oh, that was it? Well, that wasn't as bad as I thought it was going to be." And I had over a year of relief from it. But then the second shot hurt so bad and no relief. So that was why I was kind of like, I don't want shots in my back. So I told the pain management doctor that, and he's like, I've never had anybody complain about it hurting really bad. And he goes, and it shouldn't hurt really bad. And he said that I would have to have someone drive me because of it being in my back and my hip, that my leg might go numb and I wouldn't be able to drive. So I said, okay, well, let's try the shots first then. And I asked him, and he can do a nerve block too. If the shots don't help completely, then they can do a nerve block. And I asked him, I said, do you have patients that get relief from just the shots and the nerve blocks? And he said, oh, yeah, I have a lot of them. And I said, okay, well, let's try that first. Because the trial of the neurostimulator, they use, well, I would have to get another MRI, which I hate. Robbie Dobby, you know I hate MRIs. I'd have to be put under anesthesia again because I won't ever do another one awake. And then, oh, you also have to see a psychiatrist because they have to assess if you are able to manipulate the controls on the neurostimulator. Then, if it works and you want to get a permanent one that's implanted inside your body, they actually have to remove a disc, or no, not a disc, a vertebrae, part of your vertebrae. And my cousin says that that was excruciatingly painful for her. But she loves her neurostimulator. But it just, I mean, he made it sound like it was a really major surgery, whereas the neurosurgeon made it sound like it was super, super easy day stay surgery. So I said, okay, we'll back up and we'll do the shots for. After all I've been through, I shouldn't be a chicken anymore. But yeah, the one time that they made me do a closed MRI. I used to do opens, but we don't have any open ones nearby anymore. But the one time that they made me for one of my shoulder MRIs, they said, you got to do a closed one so we can get a better picture. They sedated me and I fell asleep. But every time the noise started up, it would wake me up and I would jump. So they didn't get a good picture then either. So falling asleep was not an option either. Oh, well, that's interesting. Yeah, I had to get oh, come on, computer, why aren't you showing up? There we go. I had, well, I know it's gone again. Yeah, I had to get shots when I went to Venezuela with church. I think I had to get a tetanus shot and something else. I don't remember what it was. Yeah, they said that it would be uh, a numbing. They didn't. I mean, I know what stuff is, but I guess they're used to dumbing it down for lay people. So he didn't tell me exactly what it was, but he said a numbing medicine and a steroid. So probably lidocaine and cortisone. Oh, wow. That's cool. They didn't have that when I was a pediatric nurse. I have had, now this is scary. I don't think they do this anymore. It was scary for me as a nurse. I used to have to give kids chloral hydrate for MRIs. And we weren't allowed to stay in the room with them. We were outside the room and these kids were sedated with chloral hydrate. That's scary. Absolutely terrifying when you're the nurse and you're responsible for that child. I hated when I had to do that. I only had to do it a couple times, but still, I hated it when I had to do that. So, when you got the Botox in your neck, was that for neck pain or was that for migraines? I got um a steroid injection in my neck decades ago. And at the same office that my pain management doctor is in now, he looked it up and it was so long ago I'm not even on the records anymore. And it was by a different doctor that's still there in the same office, but my records are, I guess, in a hard copy somewhere, locked up somewhere. I don't know. It's not on the computer anymore. And it helped for years. I'm just now starting to have neck problems again. And it's probably not even the same thing because before it was just neck pain. Now I can hear something clicking in here when I turn my neck sometimes. What's a wry neck? Oh, and you don't want migraines either. I'm Why don't you just take muscle relaxers to relax the muscle? My eyes are starting to itch. Why are my eyes itching? Whoa. Do we have movement? Oh, we have a clock. Do we have sound? Oh, yeah. I had that once. And I went into my doctor with my neck like this, and I'm like, Malcolm, I need some Flexeril. Prescribe me some Flexeril. And he goes, I usually don't give my patients what they ask for, but in your case, I will. Yes, clock is our new fan. Can we have some sound? There she is. Sound, please. Oh, look how nice she looks. Does she have dress shoes on or prison slides? Nancy. That dress that she wore, or whatever it was, blouse and slacks the first day, they were the same color as her prison outfit. She literally looked no different than she did any other day. She's gained some weight since she's been in jail. I have never seen that movie, but I know when people say Basic Instinct what they're talking about. Maybe she watched the Johnny Depp trial and thinks that everybody gets candy at the defense table. Oh no, Johnny was a plaintiff. Whatever. Well, she has to borrow clothes because she has nothing. Beggars can't be choosers, I guess. No, Flash fan, you want that fried chicken. Yep. Judge Fleischer do like his Skittles. I miss candy. I've lost 52 pounds though. It has been 100% worth it. Well, you're my buddy. I know you, Christian. But yes, a more feminine look would have been better. I like sour candy. When I have a second cousin that died of leukemia, and when she was having chemo, she ate sour candy to keep from getting sick. And my her sister told me about it. So when I had chemo, I started eating sour candy and I got hooked. So that's my favorite candy. Um, Nerds, Cabbage Patch Kids, um, Cabbage Patch Kids, Sour Patch Kids, whatever they're called. Um, Nerds, Ropes. Oh, what are the other things? My very, very favorites, and now I can't think of what they're called. They don't burn holes in your tongue. Somebody's making up stuff. It's become, well, we don't have anything else to do. Turn on the sound, and then we won't talk about food. I used to eat. Oh, that's true. It's always a food stream when Flash Fan is here. Dang, what are they called? Sweet tart tropes. Those. I used to eat. Hey, Hez. My husband would bring me home 2 packs of. Um, I just said it, now I forgot. Sweet tarts ropes. 2 packs. I would eat both of them in one sitting. I miss them, but I don't miss the 52 pounds that I lost. And I realized the other day, next time we go to Universal, I will be able to ride every single ride. I'm going to fit in all the seats. I'm so excited. I can't wait to go back now. Oh, I've never tried it with Nutella. I do that with peanut butter though. I have to I started buying Do they have it with Nutella where they have like the little single serve packs? That's what I have to do. Because if I just take celery and a big jar of peanut butter, I eat way too much peanut butter. So I get the
William J. for the state.
yay, we have sound.
James Owens on behalf of Sarah Boone. Tony Henderson on behalf of Sarah Boone.
Seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right. Thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force, filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified, filed October 15th, and then the defendant's amended response to same, also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th, and then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th, 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes in as one for the purposes of this hearing.
Responses to what was pre-marked as A. All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. state would move that into evidence as state 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as state C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire. That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they're asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually, it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes is nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, I cannot breathe, now she describes to the doctors that she does have bad intent. And she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper.
She never told
So,
the
Your
detectives
Honor,
about hitting his
under the
fingers.
law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we're asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
I'm a little
Love is
confused. I
blind.
wanna Make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening
Speak up,
statements.
sir.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
He got up there without knowing what he was going to argue. What kind of circus are we running here, people?
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify,
She's screwed.
what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field.
Oh, I remember
What
the
is
Zoom
step
hearing.
1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
But based on the Akendo case, which is cited by the state as to what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense. Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but
What
that
is it?
has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Just can I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt act, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th DCA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under LAD needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in?
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant
No.
the motion with
I
regard
turned it down.
to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's some state witnesses here we would like to.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Mike's, I can't hear you.
Not from the state.
You got state witnesses here, you know. She's allowed to be here to watch, I understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir. I have reviewed the 2.8 instruction prior to today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to
Just give
under
the
my
instruction
motion,
and
the
it'll cover it.
second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
Which is why we have the
It stands by
instruction.
the case
The
law cited and
instruction
that the
takes
jury
care of it.
instruction, that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about
No. The words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
Yeah.
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court for those comments, for them not to put that in there. I disagree.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is this expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from
No way.
I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regard to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records.
As
I've
am
reviewed
I.
that as well. State, you may proceed.
Because the instruction said, I'll tell you guys when it's done.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018. Third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of this treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres's medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay, I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narratives to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every
In
time,
2018?
2008.
I'm talking about the 2018 incident with regard to the plate
I
glass
have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk, or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how, I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records.
Don't look at me like that.
What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that
don't need the
reportedly took
nurse's
place on
notes.
December 24th, 2017?
They're boring.
How is it relevant?
Some of those may not be, some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Come here. I didn't do
Okay.
it.
Anything
That's
else?
it.
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose
Here.
anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use
I
in
didn't
trial.
like and Daddy did.
So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong.
Say hi.
They got these records, and I understand that they're the ninth set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021.
She's
And they
mad.
just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10, 15% for legal blood. at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death. What his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what I know. You may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it? Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was filed, what was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in that sardine?
Response.
I don't know the layout.
Can you all approach this for a second?
No, I want to hear. Don't approach. I want to hear. Okay, so stand your ground. I think that was just a case that was cited in one of the motions. So it is not stand your ground, because stand your ground in Florida allows a person to use force, including deadly force, without a duty to retreat if they are lawfully present and perceive an imminent threat. The law was enacted in 2005 and has been the subject of several legal battles and controversies. Florida's stand your ground law authorizes individuals to use deadly force without the duty to retreat if they're lawfully present and perceive an imminent threat, but it can't be invoked by aggressors during the commission of a crime or against law enforcement. So if you're just in your house chilling and someone comes in and starts beating on you, you can do whatever you want. That's the way I interpret it. Depraved heart murder. In Florida, depraved heart murder is a type of second-degree murder that occurs when someone is killed by an act that is dangerous and shows a disregard for human life, even if the killing was not premeditated. So that is why it's second-degree murder and not manslaughter. Second-degree murder is also called depraved mind or depraved heart murder, which means that the individual has evil intentions and is careless about people's lives. Even if the individual, that doesn't make sense. Even if the individual did not kill anyone. How is it second-degree murder if they didn't kill anyone?
All right, court's going to take a 15-minute recess
Doesn't make sense.
to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, well, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct. I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Okay, so well, so on the first one, what they were arguing was the state says that her statement of what happened that night shows no overt act by Jorge that he was doing anything that should put her in fear for her life. He got in the suitcase. They were laughing, playing hide and seek, whatever. She zipped it up. And then she got mad. And when he stuck his fingers through the hole that she left for him to get out, that's when she hit his fingers with the baseball bat. So apparently she did that twice because it said that she committed 2 forcible felonies and 1 non-forcible felonies. So I guess the non-forcible felony is the false imprisonment. Is that what it's called? Because she left him in the suitcase. So when he started saying, I can't breathe, that's when the malintent on her part came in. So it wasn't self-defense because he made no overt act against her. So what the state is arguing is that the jury shouldn't hear anything about self-defense until it gets brought up in trial, meaning after she testifies. And I'm not sure. I think I've heard attorneys say this in the past, but I also think that there was another trial that I watched where it wasn't the same. So I'm not sure. Right, and she rolled the suitcase. Or she says she picked it up and shook it and lost control of it. She dropped it and it flipped. I don't believe that. I think I mean, he was a little guy, but still, if you pick something up that's heavy and you drop it, it doesn't necessarily flip over. I mean, I guess it could have. I don't know. Um so they're going to wait till she gets on the stand. Now, so self-defense is the only time that the burden of proof is on the defense, right? Because the state has the burden of proof. But anytime it's self-defense, then the the defendant needs to get on the stand, like in Rittenhouse, right? Oh, I know Black Swan. Yeah, I know. I don't know what wrong mouse. Yeah, I know. Yeah, and then so she filmed after the suitcase was flipped over, and then in that other like 22-second video or whatever, the second video, it's flipped back over. So she didn't just like flip it over and then was like so drunk she didn't even think about it and got up and went upstairs and went to bed. She had enough of her thought process still left to flip it back the right way. Because the second video, it was flipped back up the right way. And she went to bed. Yes, I believe it was genuine too. And a lot of other people do too, because there's been a lot of letters written to the judge saying, please be lenient. I believe her. I was a victim too, and I believe her story. Passed out. Yes, David. She didn't go to sleep. She passed out. Yes. Yeah, I didn't believe her either at first. And then I saw her testimony. I was like, that's real. You don't fake that. And it didn't just shut off. You know, after she answered questions, it didn't just shut off. She was still like shaking and, so what the state is arguing is that the jury shouldn't hear anything about self-defense until she gets up there and she says it. And the defense agrees that they can't put the expert witness on the stand before Boone testifies, and that the issue isn't appropriate for a pretrial hearing or pretrial ruling. But that's why you do a motion in limine, because those are the motions that if the door gets open, then you can talk about it. If the door doesn't get open, then you don't talk about it. So if she never gets on the stand and talks about self-defense, then you don't go there. But that she's going to. Of course she's going to, because she's Sarah and the world revolves around her. So of course she's going to get up there and tell her side of the story. But when in the deposition where she talked to the experts, there was no overt act. She never said that he did anything to her, just that she was in fear all the time. So the motion to completely exclude self-defense is denied. So they can bring it up in their opening statement, the battered spouse. I was thinking that Owens was going to have to rewrite his whole opening statement, but I guess not. Because he is allowed to mention it in the opening statement. But Sarah has to testify to it first. Now the redactions, I like Judge Cranick. I really, really like this judge a lot. But I don't agree with him on this, because he's dead because of your actions. He said that to elicit a response from her. And it's the truth. That's not an opinion. That's the truth. He is dead. I'm sorry, my hair's driving me crazy. There was only two people in the room, her and Jorge. Two people. He's dead because of your actions. Who else was there? The Easter Bunny? He's dead because of your actions. We've seen the video. He begged her to let him out, and she didn't. That's not an opinion. That's a fact. And there's a jury instruction that says you're going to, I don't remember where I read it. It might have been in the state's response. But the jury instruction says you're going to watch police interview. Anything that the police say is not evidence. Any opinions that the police say are not evidence. It is remarks that are made to elicit a response from the interviewee, and they are not supposed to be considered evidence. And it's laid out in the jury instructions, telling them not to weigh the opinions of the law enforcement as evidence. That's why there's that instruction there. So I disagree with Kranick that should be redacted, because that jury instruction takes care of it. So I don't understand why he did that. Oh wait, that's not the one. You asked a question, and this one. No, because opening statements are not evidence. Anything the lawyers say are not evidence. Even closing arguments are not evidence. So by mentioning it in the open statement, because opening statements are excuse me, sorry. Opening statements are you are going to see this, and you're going to see that, and you're going to hear from this person, and you're going to hear from that person. So it's just like, it's like a preview, like an overview of, this is what I'm going to show you. This happened on this day, and this is what I'm going to show you. So if they say it in opening, it's not evidence. So that's why. So they can mention an opening. Yes, the Easter Bunny is innocent. Well, yeah, it's not absolution. But that was, yeah, that was the detective's point. That's what she thinks. And okay, I guess maybe that's an opinion. That's an opinion. That she thinks by saying unintentional, it absolves her of it. That part was an opinion. Yeah, and yeah, you're right. While I think the Menendez brothers have served their time and should be let go now, it wasn't self-defense, because at the time that it was pre-planned. It was pre-planned, no matter what they say, because they did go out and buy guns, and they did know at one point that they were going to have to shoot their parents. Um, um, I just lost my train of thought. There was no, they were afraid of them, and kind of like this. They were afraid of them in general, but there was no overt act at the time when they did it. So what is that? I have old eyes. I can't see that. Crystal ball. The other day in a chat, someone had put um, they were doves holding like a twig, like a peace dove, like a whole line of them. And I was like, "What is that?" And they're like, "What is what?" I said, "I don't know. It looks like a bunch of elephant butts to me." They're like, "What are you talking about?" And I'm like, "That emoji that he just put up there. I don't know what it is. I can't tell you because I don't know what it is." They're like, "Debbie, that's a dove." I was like, "Oh, it is." And these are new glasses too. I mean, new lenses, same frames, but new lenses. Okay. Oh, and you guys probably didn't hear half of that. I keep forgetting to talk into my mic. Okay, and with Jorge's medical records, the judge just told them to link the documents to the self-defense, and I don't see how um one of them, the laceration to his hand, it said something about his wife. And I don't know if it was talking about Sarah or if this happened before they were even together and it's talking about his actual wife. Let me see if I can pull it up. But why? How does that have anything to do with self-defense? Because he punched a window? My brother is a wall puncher. And he's, to my knowledge, has never punched an actual person. I won't say he never has. I'll just say to my knowledge. So how does that prove violence? Okay, so we still have the defendant's objection to state's digital exhibits to go. How long have we been on break? What do you say, 15 minutes? Well, where did the medical records one go? I think I found it. That's not the right one. I read this one yesterday. Okay, this is it. Let me see. The 2018 incident is also not relevant. The history provided by the decedent was that he put his hand through a glass window the day before, and his wife made him go to the doctor the next day. He received 2 sutures to close a 4.5 centimeter laceration. So, were they together in 2018? He died in 2020. I guess maybe the wife, quote unquote, is Sarah. Because didn't she say they've been together for 3 years? You're right. Wrong mouse. Oh, dang it. You're right, James. This could be true. So, like Owen said, if he's gonna connect it with testimony, if she testifies that he punches inanimate objects before he punches her, then that would be relevant. But if he just punches things randomly, then it's not relevant. But I remember one time that my brother, and I've probably told this story before, but my brother and my mom were having a fight. I was little. I was maybe 4 or 5 years old. And of course, I remember it because it scared me. Because, when you're little, violence is terrifying. And my brother, I don't even remember what they were fighting about. And my brother hit the wall and then just like booked it out the back door. And mom let him go. And then he was a teenager because my brothers are a lot older than me. So he came back and he's like, Mom, I think I broke my hand. Will you drive me to the emergency room? And she goes, Good. I hope you broke it. He's like, No, Mom, I'm serious. I think it's broken. She's like, Good. I'm serious too. I hope you broke it. And I don't remember anything more than that. I don't remember if he went
We're
to
back
the
on the
ER.
record, 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kestner on behalf of the state. William J. for the state.
Defense. Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can y'all approach?
Why? You just got back from break. Why are we approaching? So I'll have to ask my brother about that sometime if she ever took him to the emergency room because I don't remember. After this one is over, I'm gonna start covering the Madeline Sotu thing. I'm gonna start doing videos on that and keeping up with like hearings and stuff with that one. That's a kid one. She was 13, but that mom is despicable, if you ask me. Hang on, I got another dog to take care of. not poo. That stinks. Why not? It's Florida. What happened to the sunshine law? And then what it's called? Where we televise all of our stuff? I want to cover the Kentucky sheriff judge thing too. Flash, did they charge the mom in that case? They need to for something because she definitely knew that there was hinky stuff going on. She's just in denial. If y'all aren't familiar with the Madeline Soto case, she's a 13-year-old girl. Her mom's boyfriend was a tenant in her house. She got immunity. Oh. And she would let her daughter have sleepovers. With this man in his room to watch movies. And he took her to school one day and she was never seen again. I didn't see the eye drop trial. Wasn't the judge forgot her name. The same judge from Darrell Brooks? I wanted to see it. I don't know why I didn't watch it.
All right, court's going to step out for 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go.
For a while, before I started streaming trials, I wouldn't watch trials unless I watched it with another YouTube creator. I don't know why. And I didn't watch Murdaugh or Rittenhouse. I watched Rittenhouse. I went back and watched Rittenhouse. I think I watched that one on Law and Crime. And I went back and watched Murdaugh, but I think I watched Emily D. Baker's stream for Murdaugh. And I saw the eye drop murder thing, and it reminded me there's a movie, I can't remember what movie it is. It's some kind of a spy movie where they're in like a casino or something, and one of the casino girls puts eye drops. It's not really eye drops. They're using an eyedropper to put something in somebody's drink. I don't remember if it was to poison them or to make them sick or something. It was a spy movie. I can't remember what movie it was. But every time I think of the eye drop trial, I think of that movie. But I can't remember what movie it is. So I thought, oh, I need to watch this one. And I didn't for whatever reason. And then I found out that Judge Darrow did it. And I was like, oh man, I need to go back and watch it. I just haven't yet. Okay, come on, let's go. Defense objects to all cell phone photo evidence the state intends to introduce at trial due to relevancy, foundation, unknown origin date, and that is repetitive in nature. Defense objects to all cell phone video evidence the state intends to introduce at trial due to relevancy, foundation, unknown origin date, hearsay, and Crawford issues. Defense has no objection to the following digital exhibits, which is just a list of images. Do they not have metadata? And she said that she was documenting all of the DV on her phone. Did you guys remember to hit the like button? It could have been. My memory is horrible. It very well could have been. My dog is so weird. She has to go out the side door and come back in the front door. And then she has to sniff the front porch like she's making sure it's still her house. I don't know where Castleberry is. I'm gonna have to Google it. Apparently. Oh, it's 10 minutes north of downtown Orlando. What county is it in? It's in Seminole. Well, that explains why I couldn't find his case. It's in Seminole County. Yeah, so probably the trial will be in, well, no, because it's in Seminole County. So it won't, so the trial won't be in
All right, we're
Orlando.
back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, let me get appearances.
William J. for the state.
Defense. Thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's fifth amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
I did want to say that the notice of provision of defendant's fifth amendment exhibit list was e-filed on October 3rd. The fifth list was emailed to the state on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir. Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be.
It makes it relevant if it's
the
relevant.
foundation is laid. That's my problem with these photograph exhibits is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing, so I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve-out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos. There is metadata that comes with all those files.
Thank you.
So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
So just to give the court an example. On page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline as a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020, culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him. So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, like case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we set. We believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as like the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the Second District Court of Appeal decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the Fourth District Court of Appeal decided in 2018. Gale, G-A-Y-L-E versus State, 216 Southern 3rd, 656, Fourth District Court of Appeal case as well in 2017. The basics of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Miss Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay, and it's not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Judge, I think this procedure calls for a lot of speculation as to the defense, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. It
Correct.
is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case.
You gotta
That's
wait till
calls for me to
trial.
speculate how it fits into their theory of the case.
You have to wait
can
until
I do that?
trial
If they show you a picture,
and let
like a
them lay
picture of artwork,
foundation.
all right, I don't
I don't
know
like this
how
lawyer.
that's relevant to this case, or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know?
You wait till
That's
trial.
the thing when well,
And
I
then
think
you
the procedure
object.
goes like this. Yeah, I could be wrong, but I don't think
You
so.
are.
The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection. I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
The suitcase video is listed in the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
State conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So
That's
I
not
don't
what
know
that
what
says.
we're missing.
Anything else, sir?
Well, Yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then y'all parachuted in on August the 30th.
Yes,
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se. And to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blah-bitty with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint, for the ones that we didn't list a number and I didn't give detail as to, like, IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state during its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State?
Whoa.
Response? If any?
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any. Okay, I see two images. I couldn't recognize it as reflection of children in I don't know if it's a snow globe in a aquarium or whatnot, but I have no objection to moving those two. I recognize it as crowd.
I haven't seen the picture, so I'm at a loss.
Well,
I'm sorry, Judge.
extraordinary file name, but I'm going to remove those two
Okay.
exhibits that they're
Can I
talking
take care of that issue for you,
That,
sir?
that takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now? They can make a proffer. I understand they can make a proffer, but they're proffering evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
All right, thank you very much. Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Okay, all right. So here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
What? I don't know how to make it. Can you guys hear me? Because it just said I lost connection to my audio. What? Aggravating me. Okay, that's it. I don't know how to make it any bigger than that. I can't even tell if that's her. And if you click on visit, the picture doesn't show up. But see how little he is? And he was 10 when this happened. So this is an old picture. Oh, I don't see an edit. Uh-oh, what did I do? Am I still here? If you click the photo, it just goes to that Reddit thread, and then the picture's not there, which I don't understand. So you can't, and then other versions of it I found, both of their faces are blurred out. So I don't know. Okay. Robbie Dobby, are you still here? I was going to go over what you missed. Which I kind of recapped part of this before, but so the first motion in limine was the battered spouse syndrome. The state claims that her statements had no overt act by Jorge. I guess we're calling him Jorge now. Well, I'm using Chrome because I'm using StreamYard, but I prefer Firefox because when I do my true crime videos, if you right click, then you can take a screenshot and then you can do whatever you want with it. And you can't do that with Chrome. If I was using Firefox, I could do it, but so there's no overt act, and she committed 2 forcible felonies, which were when he stuck his fingers out. So she did leave it unzipped enough for him to stick his fingers out. But then she hit them with a baseball bat twice. And 1 non-forcible felony, which was false imprisonment. And when he said, I can't breathe, that's when she had the malintent to leave him in there. So it wasn't self-defense. So the jury should not hear the self-defense until it's brought up in the trial. The state didn't want the defense to even mention battered spouse syndrome in their opening statement. The defense said that they agreed that they could not put the expert, Julie Harper, on the stand to talk about the battered spouse syndrome until Sarah got on the stand. I'm going to kill that dog. I don't know what he wants. So they realize that it's not appropriate for the expert. I'm talking. What do you want? Hang on. Talk amongst yourselves. Last time I let you out, you turned around and came right back in. Go. And stay this time. Go. Go. I always lock the doors out of habit when I let the dogs out. And my husband always says, why are you locking the door? You locked them out. I'm like, what? Like they're going to turn the knob and come back in on their own? I have to get up to let them back in anyway. Okay, where did I leave off? Okay, so the defense realizes that they can't put the expert on the stand before they put Sarah on the stand to tell her side of the story and how. Whoa. I thought I shut that off. Oh, yeah, doggy doors would be nice. um, I had a cat that I swore I could have taught her how to use the doorbell, because there was a chair next, like in front of our front, or next to our front door, and she would get up on the chair and knock on the glass when she wanted to. Check link. What link? She would knock on the window when she wanted back in. That was a cat. She was an indoor outdoor cat, and she would come knock on the window. And the doorbell was right there. I was like, I've got to teach her how to use that doorbell. So Sarah's gonna testify before Harper, and so they knew that. So like they didn't put up much of a fight. And the state's rebuttal was that when Sarah's directly asked, there's no overact by Jorge. And the defense says the overact is his hand coming out of the suitcase. His hand didn't come out of the suitcase, just the fingers came out of the suitcase. And then she hit them with the baseball bat. So I can't see how that's an overt act. Just fingers coming out of the suitcase. I mean, even if he like shot her a bird out of the suitcase, that wouldn't be an overt act of violence. I mean, if she's going to say that, maybe she might have thought that was an overt act of violence, but still, she hit his hand with the baseball bat. So it's not self-defense. Any way you look at it, can anybody think of any scenario where that's self-defense? I can't. And yeah, he probably didn't try to do it after the second time that she hit his hand with the bat. I wouldn't. So it was denied in part and granted in part. So it's not excluded. She can use her self-defense. And battered spouse syndrome can be mentioned in the opening argument. But testimony about it, because remember, opening statements are not testimony. So it can be mentioned in the opening statement. But for it to be admitted as evidence in the trial, it has to be testified to first. So she has to get up there and say that she was in fear for her life, and it has to be believable. She absolutely could have called the police. I mean, she could have called the police. I mean, this is going to sound dumb, but I mean, leaving a man in a suitcase to die is dumb. But she could have even called the police while he was still in the suitcase and say, we were playing around. He got in the suitcase. I'm afraid of him. I'm afraid to let him out. Please come help. She might have gotten in trouble for leaving him in the suitcase, but he would still be alive, right? So right. Yeah. He put himself in the case. She zipped him up as a joke. They were joking around. Then she got scared because then she thought, oh, when he gets out, he's going to hurt me. So then call the cop, call the police. she also could have done that. She could have left the house. So the next one was the redaction of the interview when the cop said, "He's dead because of your actions." This is the one that I disagree with the judge because he granted that. So that is going to be redacted out of that interview. Because there is a jury instruction that says that law enforcement opinions are not evidence. And it says you are about to watch an interview with law enforcement. Anything law enforcement says is opinion and not evidence. And I was thinking, well, saying he's dead because of your actions is not an opinion. But what he said that may be considered an opinion is you think just because you say unintentional that it absolves you from any responsibility. That exactly, Nancy. Exactly. Yeah, but he wasn't beating on her at the time. You know, like that one case that that the state cited. You know, you can't get a text from somebody that says that they're going to kill you, and then if they come in your house 2 weeks later, you can't slit their throat just because they sent you a threatening text 2 weeks ago. And his medical records, what the judge, again, Owens was not prepared. He had not gone through and decided what was relevant and what was not. And the judge ruled that the medical records, the ones that were linked to self-defense, would be admissible. And as a nurse, I can tell you medical stuff generates a lot of paperwork. A lot that is not understandable, is very confusing, and would not be relevant to a court case unless it is a malpractice or wrongful death case. There's no reason for every single one of his medical records to be admitted into this case, especially if he had reconstructive facial surgery. There is no reason for all 550 pages. That's why I thought 55 was a lot. I thought that's what it was 55. Because no way did I think every single one of his records was admitted, like every page of the records. 550, that sounds reasonable for, a hospital stay with surgery and all that. Plus, the other incident, I guess, was just from a doctor's visit to get stitches in his hand. And like you said, like somebody said about, I don't remember who said it. One of you guys said it about if that does correlate to he hits something first before he starts hitting her, then yes, that's relevant. But if there's no correlation between the two, then that's not relevant. So they have to make it make sense. They have to, and it's just, you don't want the jury, because the jury gets all of this. It gets all of this. So you don't want a bunch of stuff that makes no sense to the case going back with the jury, because it's just going to confuse them. It's just too much information for them to wade through. So, and the digital, this I don't like Henderson. Tell you that right now. Number one, he's not loud enough. I can barely hear him. Number two, his arguments don't make any sense. He gets up there and he says, well, I want them excluded because I don't know if they're relevant. What? That doesn't make any sense. Yeah, they're numbered images on a piece of paper right now. Nobody knows if they're relevant. When they're presented at trial, that's when I'm purposely leaving him outside. He's going around to every door of the house barking now. It's 65 degrees out today, y'all. He's not out there in the Florida heat. It's nice out. He does want the objection on the record, but he's saying, well, I don't know if they're relevant or not because I don't know when they were taken. I don't know the dates. I don't know the context. Well, it's got metadata. The state said it's got metadata. Yeah, look at the metadata. It will tell you the date. The metadata tells you the date. And the state, like the state said, if it's a picture of artwork, they're gonna anytime you show anything in court, the person on the stand has to be there to authenticate it. So there's gonna be some witness testimony. There's gonna be some witness testimony that's gonna say why that picture is in evidence. And he's going to have the chance to object at trial if he doesn't want anybody to see it. But I think where he's coming from, I think that he is under the belief that he won't be allowed to object to it at trial, which is completely not correct. And I don't know. Well, I don't watch a lot of these motion and limine hearings, but I don't believe that I've ever known a lawyer to object on those grounds. Why would he think he couldn't object at trial? But apparently that's what his thinking was. I need to get them all excluded now because I can't object once the trial starts. But that's not the case. So that's no. But he just got up there. He's like, well, I don't know if it's relevant. Yeah, because we haven't gone to trial yet. So, okay, well, I wonder if we're going to get... He's not a Florida lawyer? Oh, hello. Germany, wow. Yeah. Yeah, that's exactly what it seemed like. He wanted the state to right there, like, tell him their whole case and why everything would be relevant, but he didn't want to say anything about their case. Yeah, that's exactly right. That's what the trial's for. Unless you're the Burn trial, Burn pile murder in Georgia. Have you guys been watching that one? No one is objecting about anything. And people are just getting up there and it's great big long narratives about nothing. That's half of it's not even relevant to the trial. It's been a slog fest, man. And I missed all morning because of this, but I'll get caught up. So I guess that's it. And I don't know. Hopefully we'll have opening statements tomorrow. If not, I guess Friday. Yeah, he's got to be licensed in Florida unless, I don't know what it's called. It's got a special name. When you can like vouch for somebody from another state and bring them in to help you with a case. There's a name for that. I don't remember what it is. Yeah, that's the Georgia case, Flash. Melody Ferris. She supposedly shot her husband and disposed of him on their burn pile on their farm. My dog is having a fit. Oh, thank you. Prohicvice? Is that right? Did I say it right? Whoop, wrong one. Prohicvice? Yeah, but they've not. All they've proven is that he's dead. There's no evidence that points to who did it. Oh, I think they're just from like a different county. And I guess there's little differences in every county. So, okay, well, let me go try to figure out what this dog wants. He's such a brat. And I will see you guys, I guess, tomorrow. I don't know. I don't know when opening statements are going to start. Hopefully the latest tomorrow afternoon. Maybe they'll get it all straightened out today and we can start the real stuff tomorrow. So, thank you guys so much for showing up. This has been fun. I can't wait to get this show on the road. It's going to be spicy. Bye. Take it easy. Have a good rest of your day, y'all. Appreciate you.